All right, so why don't we get started, because there's a snowstorm on the way, but I think we should be in good shape. I don't think that should be a detriment. And like I said, if we get stuck here, we do have enough food in the back for a week. So.
We're not stuck here. We have an exam.
Oh yeah, I forget. You guys have an exam following this exam. Some people do, not everyone. So you guys, I think, will be fine for that exam as well. So in any event, so let's pick up where we left off. Let me just summarize what we covered, what we're doing today, what the future has in store for us. So the introduction, is just talking about as a tax professional. Come on in, guys.
Good morning.
Now we have more food for a week.
Oh
my God. Guys.
Is it like the story, The Gift of the Magi?
The Gift of the Magi. If you haven't read that, I recently read it. Everyone's read The Gift, but you haven't read it in a while, and I read it. Very romantic.
Oh. Yeah.
So if you get a chance, reread it.
Thank you.
And then some of this food maybe you'll bring for your next exam, because there'll be some starving students.
Yeah, we take it.
Would be interested. So we looked at the introduction. We looked at chapter 1. Chapter 1 talks about sources of professional regulation, because we always hear people talking about or you hear me spout repeatedly, what's your authority?
Do you have that on bumper sticker yet?
I should. In fact, I think I really annoyed my co-author, because I'm working with several different co-authors, but I'm working with one, since we're being taped, I won't say her name, but I am sure I'm totally on her nerves, because we're writing this piece. I'm hoping it will be done by next week, but it's about people setting up life estates to save money, or they think they're going to save money for Medicaid purposes. And on good days, I like to think I know a lot about the Internal Revenue Code. Not always sure, but I'm sure of one thing, that I'm not really well educated in Medicaid. But there's a lot of people who engage in Medicaid planning. And the notion of joining forces with this co-author was I was going to write the mainstay pertaining to estate and gift tax, and she was the specialist in Medicaid. Well, I wrote my piece, and it's all footnoted, and I've got all these cites to the Internal Revenue Code in different cases and whatnot. And I wrote a portion of her piece, but I said, you got to elaborate. I don't really have good command of this. And she did. But then there's no citations. And I said, the readership cannot just go on the basis of what the two of us say. They want to know in Title 42, which deals with Medicaid, what is your authority? She said she'd get back. She sent something back. Again, lackluster. That's all I can say. And she agreed with me. Well, you're right. So I am twisting arms. I will be anxious to see this upcoming week. You're reminding me, as I say it, to pursue this.
Let's hope she doesn't watch this video.
Yeah, I am hoping she doesn't watch this video. So just delete it after whoever's not here, if you could. All right. So we have sources of authority, sources of professional regulation, and we say they come in several different flavors, whether it be the code, Circular 230, or the professional standards set up by the AICPA or the state licensing board. And we talked about the fact there's some cases here that if you fall short of the mark, you run the risk of the Office of Professional Responsibility coming after you. In the chapter that follows, Chapter 2, Tax Return Preparation and Advice, we talked about the penalties, and like I said, it's very important to bifurcate it. What are the penalties that tax return preparers can face? What are the tax penalties your client can face? And the two are somewhat interrelated. but there's not overlap. Now, Ping was kind enough, and I will see if I can distribute this vis-a-vis Blackboard. Apparently the IRS has on its website.
Yeah.
So remember, the exam's open book, so open note, open whatever, so feel free, and you can probably pull this up yourself, but there is a summary of preparer penalties under Title 26. You can see it is well beyond Code Section 6694, but in your, Peter had mentioned, Internal Revenue Code that you guys have do not include all the penalties, right? Because this is an abridged version, all right? So, and what do you Google to get that up?
Just I did on summary of prepared penalties.
Summary of preparer penalties, you can pull it up. You don't even need me to give you a Blackboard. And I presume the first site is the IRS site, all right?
I can email it to you back, you can just send.
All right, if you could, and then there's another site that deals with taxpayer penalties, and this involves the penalties that we had spoken about before, and the different thresholds and amounts. But again, these are the kind of things, I don't say you have to commit everything to memory, but it's so useful, I think, because clients always will ask you these kind of questions. What's their downside risk if they don't file on time, if they don't pay on time, if they take aggressive tax positions? And the signature mark of an aggressive tax position is what? What's my translation? What's the signature mark of an aggressive tax position? And I'm just talking, when you talk to your clients, what's the verbiage you want to say? If a client wants to take an aggressive tax position, what would you say, Omari?
Significant understatement.
Well, what would you say is lacking? That's the only thing.
Reasonable basis.
Would you say reasonable basis, V?
Substantial authority.
Substantial authority, right? Everyone agree? That you would want to say your position lacks substantial authority.
Therefore, you disclosure is.
I mean, you can cure that potentially if it has reasonable basis plus disclosure. There is a method to cure, but I think the starting point in a conversation with your clients would be, hey, they want to take some position, you're not comfortable with it. You have a right to say, hey, I don't think that position has substantial authority. I can't sign your return, but if you want, let's make disclosure because there may be a reasonable basis for it. It can't be frivolous, okay? That's going to get you in trouble. So you have to have some basis for embracing that position. So
how does signing the return go with electronics?
when you say if you are
Meaning, when you say signing, I literally mean signing.
no, I meant like you're the return preparer, your PTIN numbers on it.
In that scenario, I'm not gonna sign it, so how do you, if it's electronically filed?
I'm not going to file it then.
Got it, so they'd have to mail it,
Yeah.
right?
Yeah. But you got to be careful because if you're being paid to prepare it, the fact you're not signing it doesn't, I think, absolve you of liability.
Got it.
All right? Because then if you prepared it, you could get yourself into just a simple 6695 penalty. You should be signing it. You can't just prepare a return and say, I don't agree with it, but good luck to you.
Make them sign something and say they understand you didn't want to.
I don't think you can sign the return unless it meets certain thresholds.
Well, no, I'm saying you don't sign it, you make them sign separate, like an affidavit saying they opted to file this, understanding that I disagree with the position kind of thing.
You might be able to get away with that.
Because obviously if they're just gonna take the work that they paid you to do thus
But
far.
you,
and just
they
file
could
it.
query whether or not you should have prepared the return with a flaw in it,
Mm.
right? I mean, those are the kind of things, guys, you keep no good deed. So it's, you're not gonna win any brownie points, so just be careful. Aggressive clients, if they're aggressive in the tax sphere, guess where they're gonna be aggressive too? They're coming after you. So, just a word to the wise. And we went through this, guys, I know one last time. I'm not gonna do it next class, okay? But Pink, just tell us the penalties that taxpayers have to, what kind of penalties, and Ming, just if she left any out. So, just quickly, what are some of the penalties, Pink? Last time, I'm not gonna say it again.
Substantial, understand, no. Accuracy related for the taxpayer, and also possible for the, what they say is like, prepare, definitely have understanding.
But go, just say it summary, I'm a client. What are some of the penalties I might face?
If it's late, there will be.
What's the penalty?
0.5%.
What is
For
late?
the late payment, and then they fine is 5%.
Is that unlimited?
No, it's up to 5 months.
Okay, so up to 25%, right?
Yes.
And the late payment
Late
isn't
payment.
capped at 5 months, it keeps going and can be a penalty up to 25%, right?
Mhm.
Any other penalties?
And the accuracy related penalty will be 20. It's 25%. It's 20% to
Right.
40%.
20% generally, sometimes in the
Sometimes it's
absence, when
40%.
dealing with tax shelters, 40%, right?
Yes.
Or gross
And then
misstatements,
fraud, 75%.
75%, right? Anytime I can get out of jail free, Ming, any get out of jail free code sections? What's my cryptic comment about?
Not sure.
Mike, what am I saying?
I don't understand the questions.
Yeah, I don't know if anyone understands my question. How do you get at, what defense can you launch on behalf of your client to try to defeat the penalty?
So reasonable basis.
Reasonable cause,
Yeah.
right? Code section 6664, right? So the fact the IRS imposes the penalty, you might counter it with substantial authority or argue there is some sort of reasonable cause. And reasonable cause depends on the circumstances, right? If you have a novice taxpayer and he or she paid big bucks to a large accounting firm, the accounting firm just rendered bad advice, but the client wouldn't or shouldn't have known better, then generally the client would not have to pay the penalty, right? Now, with respect to tax return preparers, Andrew, what kind of penalties do they have, and what are they looking at?
I don't really have it memorized, I'm sorry.
It's okay, but
I always just pull them up.
You just pull them up. But again, clients are gonna
I know.
wonder too, what's your downside, Nick, for doing this?
I think it's 5,000 or 50% of the fee earned.
Okay. It depends, you know, if it's reckless or not. I think the starting point is 1,000 or 50%, the greater of,
Greater than 1,000 or
Greater
10%
than-
on the rise.
right? Or if it's reckless, right, it's
Like
5,000 for
50%.
50%. You know, maybe something I should take back on this tax shelter I've been working as an expert witness on. You know what the fees were? I always sort of, maybe I charge too little, but I never think of accounting and legal fees being, 50%, not the big enchilada, but in this tax shelter advice, this case that I'm working on, you know what the fees paid were? So, give me a real number. It was $18 million for the fees.
It's based on the hour or based on the case?
They just charged these tax shelters, the way they made money, they did it as percentage of the tax savings. I mean, these were aggressive. In fact, I'm being sent a video from the plaintiff's attorney sending me a video that apparently has the tax solution department, where they had a party and the tax solution department has songs like Money, Money, Money playing in the background, and they have a live wolf on stage, and suggesting that you gotta be really aggressive with your clients. They were known as the Wolf Pack, and they aggressively went after their client base to quote unquote save them millions of dollars, and they charged a fee based on the percentage of tax savings. So when my client had secured $250 million of options, well, do the arithmetic, we can save you tax on that. Well, our fee is small compared to the tax savings, right? So that can be a pretty hefty penalty. So I can't. Now, you know, many times it won't be, because last I checked, at least maybe your fees and my fees don't amount to $18 million a shot, but that can be the real number. All right, and we went through in chapter 2, computing some of those and figuring them out, and I hope you have a good handle. I mean, part of the purpose of this course is just that you keep that, Andrew, you gotta keep that with you, right? Okay? I know you can always say to your client, you can look it up, but part of the eloquence of all this is that they could look it up too, but you can just speak like from this wealth of knowledge that you bring to the table. It's very impressive. Right? So, and we talked about amended returns and when you should or shouldn't do them. We talked about Ridgely and Loving and the role they play in the year 2019 and what, if anything, is around the corner. Our goal today is to try to get through the bulk, if not the entirety, of chapter 3, dealing with conflicts. I said it was the #1 reason that accountants and lawyers, aside from shortcomings in their work, the #1 reason that accountants, lawyers, like I said, may be sued. And then, time permitting, we will begin to look at chapter 4. Chapter 4 deals with client confidentiality and what role that plays. And I will also try to draw attention at the very end of class to something known as the work product doctrine. And many practitioners, including myself, but not so much anymore, in yesteryear, but many practitioners conflate, is probably the right verb, conflate what is attorney-client privilege and the work product doctrine, okay? But for exam purposes and going forward for your purposes, those are two entirely and separate doctrines, okay? So I will try to highlight that point towards the end of class. Why? Because when you read chapter 4, I don't want you to conflate, like other people do, including myself at the younger stage of my career, these two very different concepts, but they're easy to conflate, all right? Questions, issues, concerns? All right. All right, so let's pick up with chapter 3. Talked about client conflicts, and at the AICPA, we have in Appendix H, says where possible that you should look to avoid client conflicts. And we went through several problems dealing with potential client conflicts. And I kept emphasizing, I think I did, that one curative method, John, was what when it came to client conflicts? Then other John, you can chime in too. What if you have potential client conflict? What can you possibly do?
Tell them to lose your number.
I'm sorry?
Tell them to lose your number.
That's one thing, to lose your number.
The waiver. Waiver and disclosure.
The waiver. Waiver and disclosure, but losing your number sometimes can be important too, right? Absolutely. Maybe I'm haunted that by my younger days. All right, so we went through the problems. We talked about business planning for newly formed entities. And who is the client? I told you in yesteryear that the importance of getting a retainer letter and why retainer letters have changed my existence and orientation, because by getting a retainer letter, like I said, I know this sounds crazy, but it helps you identify who is your client, which you might say, that's the easiest thing in the world. The person walked through the door, I know who my client is. But I have, in many instances, once they walk through the door, it's not entirely clear who you represent. And that becomes even more problematic. I don't know if the book does this justice, but particularly when it comes to estate planning issues, and you have the family walk through the door, and people harbor different expectations. So it becomes an interesting ordeal. I believe, correct me if I'm wrong, your notes should leave off with problem 3-6, right? All right, so let's pick up with the case on page 109, the War v. Commissioner. And some of you may be Nat King Cole fans, maybe not in the crowd. If some of you might be scratching your head, who is Nat King Cole? Fair statement. But most of you, I think, no. Can't say I'm the biggest fan, but certainly.
One of those ID channels did a show on this. I remember.
Did a show
which one? Yeah, on the stage, and I think it covered this height.
Really? So talk to us about it. So
I
you.
kind of remember. I just remember they were talking about the estate of Nat King Cole. I got the show, but I wasn't paying attention because my wife was watching it. But I was just listening to it.
Maybe subconsciously got into your brain, but.
I just remember that the estate of it. I always show it. There's a show on one of those ID channels that goes over famous estates and wills.
Did you have a chance to look at the case?
Oh yeah.
All right, so you want to tell us about what went on here, and why it became a tax court case? Or in this case, it went up to the 9th Circuit, not President Trump's favorite circuit.
Well, I think there was.
Or John, you want to chime in too? Remember what happened here? Who are the parties here? Right? Ray Cole was married to Nat King Cole. Nat King Cole unfortunately dies, right?
She remarries, right?
Say again?
She remarries.
She remarries.
Less money.
Say again, Omar?
She marries someone with less money.
Yeah, this is, she marries someone with a lot less money, right?
And then I think he was liable for the taxes that she accumulated. At least that's what I got.
Apparently there were some big issues pertaining to payment or underpayment of their taxes. Was it the happiest of marriage, these two? I don't think,
Yeah.
if divorce is any sign, it
Right.
wasn't a happy marriage unless.
Yeah.
So they get divorced, and their attorney and accountant, it seems to me, continue to represent them, right?
Yeah.
And they're gonna go to battle with the IRS over the proposed assessment. And the question is, did he get fair representation, right? Should the attorney represent both of them? So on top of page 110, DeBoer moved through new counsel to vacate the tax court's deficiency judgments. He asserted that when counsel represented him and Cole jointly, a conflict of interest resulted. And the court goes on and points out he was unsophisticated. And if you look under discussion, third paragraph down, there's a case on point. Wilson v. Commissioner. Husband and wife filed joint returns. The husband earned much more than his wife. Deficiency judgment was entered. through the tax proceeding, they were jointly represented by the same attorney. However, they were also engaged in a simultaneous annulment action. In the annulment action, the husband was represented by the same attorney who represented the couple in the tax proceedings. So assuming he represented, can you picture this? The husband is being represented by one attorney, and then that same attorney is representing the husband and wife in a tax action. Do you think he could give disinterested, zealous advice to the wife in these circumstances? Your answer has to be categorically not, right? And what is the code section that probably the wife, and in our case here, DeBoer, sought to invoke? The authors allude to this. There's a code section, many of you probably are familiar with it, called Innocent Spouse Relief. Code section 6015. It used to be 6013, it was renumbered 1615, that a spouse can invoke. Now, it's not easy to invoke, okay? If you're living the Vita Loca with your spouse, and you know that your spouse isn't reporting much income, it's hard to invoke innocent spouse relief. But if your spouse is making a lot of money, let's say I'll use he, the pronoun he, is living the Vita Loca, say with a girlfriend across the country, and you're living in a shack in Hackensack or Picture Town, and you have no clue that your husband's making all this money, you might have grounds to invoke code section 1615 and say you should not be responsible for the tax liability, right? So different fact patterns may get you different places, but needless to say, if you're a wife in the example I just cited, you don't want to be simultaneously represented by the husband's counsel, because the husband's counsel wants you jointly and severally liable. Where if you can invoke innocent spouse relief, the entire onus falls on and again, in my fact pattern, the husband. So, Omari, who prevails here? Remember?
I thought the husband prevailed.
The husband does prevail. The court does grant relief. It says he should have had separate counsel. Okay. So that he was prejudiced. And if you read the first paragraph on page 111, it says the Dewari case was somewhat unique in that the aggrieved spouse was the ex-husband. Most often, innocent spouse claims were made by the ex-wife. Why? And you guys say, why is it usually the ex-wife?
Unfortunately, that seems to make more than
Oh, right. I thought you were going to go somewhere else with that
Overall?
statement. I didn't know where you're going.
It's unfortunate, I have 4 daughters.
All right. In the world that we live in, for a whole host of reasons, at least economically, I don't know what the stats are exactly, men tend to make more. Obviously, there's exceptions to that. So the women are more in a position to claim innocent spouse relief. What special responsibilities does this impose on a lawyer who perhaps has a pre-existing relationship with the ex-husband? Well, given what we just said, what does that seem to suggest? That in most instances, that attorney cannot also represent the wife. Or what should you seek to secure, guys?
Waiver disclosure.
Waiver disclosure through informed disclosure.
Both husband and wife have to.
Yep.
Have to sign, whereby the attorney has to be able to share each of the changes to each other.
Right.
So if there's a change in the husband, the wife is entitled, and vice versa. So if a conflict arises and a decision like that, but
Gotta get informed consent, right? And you gotta be detailed about, I would, beyond the informed consent, point out that depending on the circumstances, the husband or wife might be entitled to innocent spouse relief but that they have decided that neither is situated to avail themselves of that. So you might want to take that informed consent and to spell out the consequences that this would preclude either one's ability to make to try to rely on innocent spouse relief. All right. So let's look at problem 3-7. You have represented Mr. and Mrs. Mildew in connection with their audit of their joint income tax returns. Following the audit, the IRS issues a joint notice of deficiency. You prepare a petition which they both sign, which is then filed in tax court. 2 weeks before the case is scheduled to go to trial, Mrs. Mildew calls and says they're getting a divorce. She tells you that her divorce lawyer has discovered her husband was skimming cash receipts out of their jointly owned restaurant without reporting them on the couple's tax returns. What are your ethical obligations and other obligations to each of the Mildews, IRS counsel, and the tax court? So, do you have potential conflict of interest here? If you're the attorney, maybe even the accountant, Kevin, what do you think?
Well, being that she discovered the receipts, the first thing I would tell her besides the letter is to try to seek spousal relief.
So can you continue, can the accountant file joint return? Can the lawyer continue to represent both of them?
No,
in tax
unless he has some sort of waiver, but I wouldn't do it personally.
Yeah, I think at this point, the fact and Kevin's point's a good one. She discovered, so that insinuates, right, that this may be a good case of innocent spouse, right? That this might be one of those cases where innocent spouse relief is appropriate. So certainly the tax court, this is something that they should have separate counsel. Once you learn that the husband was truly skimming receipts, query whether or not, assuming that's true, you got to ask your client if that's true, and you were the attorney or you were the accountant help prepare the returns, and now you learned your client lied. Maybe you got to rethink whether or not you should be on this case, because you, as the advocate for the client, should not be perpetuating fraud on the court, right? So, if you learn that there's something there, you better consider whether or not, aside from instructing the spouse that she should seek legal counsel or separate legal counsel, you may have to withdraw yourself. And then, if you recall from what Bob Stern said, when it comes to these cases, you remember the case, did you write it down in your notes, that during the matrimonial, if the spouse says, hey, you're reporting these receipts, do you remember the case name?
Sheridan?
Sheridan. Okay, that's a big case in New Jersey. And that often comes up because many couples, when they divorce, all of a sudden, they want to go for the jugular. One way to go to the jugular is to incriminate your spouse. Right? So there's the point is, once you learn certain things about your clients, you have to rethink the relationship with your clients plural in this case, the husband and wife, whether or not you're going to represent the wife, whether or not you're going to continue representing the husband, and what are your responsibilities, again, to the attorneys opposing counsel from the IRS. If you learn this and you think there's credible evidence that your client truly was misleading you, and by extension you, the IRS, where does this put you? Now ideally, and this is where client confidentiality comes in, you're supposed to be able to have this communication in confidence with your client, so he or she can be forthcoming. Because if you learn that maybe there was a problem with what income was reported, you make it, you seek immediate settlement with the IRS in some form or fashion. And if you learn your client's going to be recalcitrant and stick to the guns and say, well, they'll never find out, then I think you truly have an obligation to withdraw from representing that client. Easier said than done, let's just put that. Because remember, you may have sank, you and the attorney, you're the accountant on it, I'm making up numbers, $10,000, $20,000, $30,000 worth of time. And now when you say to the client, look, I gotta withdraw, it gets into a really tricky situation because they're like, well, if I hire another attorney to get that attorney and accountant, because you're the accountant, you don't want to be part of this, and they have to hire a new attorney or accountant, just to get up to speed, it may cost another $5,000, $10,000, $15,000, $20,000. So your client is really aggravated. And aggravated clients are not good clients, right? They're mad at the whole situation, and they can't take it out on their ex. They might seek to take it out on you. So it can be a problem. Okay, 3-8, so I'm sorry, on a Saturday morning you'd like to have more black and white answers. I can't give you black and white here. I can just say it's problematic and explain some of the problems. And just so you know, for the exam, they're short answer questions. They're not, many of you are used to a combination on my exams of short answers and multiple choice. Ain't no multiple choice here, guys, all right? There are a bunch of just fact patterns, very similar to this, where I just need your, how would you handle it kind of situation, all right? So just to give you a more foreshadowing. So if you go through these problems in the book and you have a pretty good command, you should do fine on the exam. Problem 3-8, practitioner prepared a joint return filed by a married couple. The couple later divorced. A practitioner represent both spouses in connection with an IRS challenge to the expenses that were claimed on the joint return. Then it's note, Code Section 1613, innocent spouse relief, which was a relief provision at the time the divorce case was decided, has been replaced by 1615. Does your analysis change because of the statutory change? What must practitioner do if she decides to accept the representation? I think you guys have gone down this path before. Nick, what do you say here?
Waiver disclosure.
I mean, you really have to, in this case, if you want to represent both of them, and there is economies of scale with having one attorney instead of two. So definitely, if there is no opportunity for innocent spouse, there's no reason why, because they're jointly and severally liable, why one attorney or one accountant together might not handle this matter. But you should put your cards on the table, okay, and get it in writing. Okay, guys, this is not something where, yeah, my client told me so. We had that conversation on the phone last week or several months ago. You need it in writing, guys. Not good enough that your client somehow consented to joint representation on the phone or elsewise. Problem 3-9, several years ago, before a husband married wife, lawyer represented husband in connection with the formation of a business venture. Recently, wife approached lawyer to request representation in divorce proceedings against husband. Can lawyer accept this representation? Eva, I think you.
No.
And tell us why.
Actually, before that, he already represents husband, so he knows all the matters on the husband.
Right, so he comes to the table, he knows all the business dealings the husband has, he knows the inside scoop, which may or may not be known to the wife. And we know, guys, that you're not supposed to ideally ever sue even a former claim, okay? And Model Rule 1.9C that the authors reference, you can Google it. It states that a lawyer may not use information that they've obtained by one representation to the disadvantage of another representation, which makes sense, right? Because again, the system should be designed where people can be as forthcoming as possible and not worry at some point that their disclosure of information may come back to haunt them, right? So these rules are designed to incentivize, again, people to be really forthcoming.
In page 111, the note before that, when the lawyer can represent both husband and wife.
Right? I'm not sure, I'm looking at page 111.
Yeah, on the bottom, comment 7.
Comment 7. Says, a more recent case in which innocent spouse was this Harbin case, or represented both spouses in audit and tax court litigation without raising a viable innocent spouse claim. He had also represented both spouses, wow, this is dangerous, in a contentious divorce, okay? Notice the exclamation point there. The husband clearly blamed the wife for their tax problems, which resulted from her substantial gambling activities. By the way, I'm not sure how your tax problems result unless you win a lot, which is not usually the case, and that's usually not the problem. So and gambling losses, can you claim? Only up to your gambling winnings, which usually are pretty small. So gambling losses, generally you cannot deduct. The court found that the attorney had a conflict of interest, which is pretty obvious, which he had neither disclosed to the couple nor sought to have them waived. The husband was later permitted to request innocent spouse relief. Well, isn't that the same fact pattern we have with divorce?
But in this case, the lawyer represented both of them.
Is that what happened in divorce?
Yes.
So I'm just asking you what's, I mean, the fact patterns are almost identical.
Yeah.
But, guys, I mean, you might say, looking at this case and reading 2 or 3 sentences, like, this is insane. That's the only thing I can say. Like, and accountants do the same thing. I mean, I see this all the time. And what ends up happening is 9 out of 10 times it doesn't come back to haunt you for whatever reason. People don't have the energy to pursue you. They don't. There's a lot of reasons that subsequently, but it's 1 out of 10. Would you guys ever take a, I hate to be graphic, Russian roulette? You had a chamber with 10 bullets. Would you ever put 1 in and just say, I'll take a chance today? So 1 out of 10 is a pretty big percentage of risk. Way too much risk for my bloodstream. So, just be really careful, guys. That you read that, this footnote 7, and you're reading about a lawyer representing husband and wife in a contentious divorce. Both of them. And I have a neighbor I'm having dinner with tonight, and he does the same thing routinely. And my wife and I are like scratching our head, how does he do it? And apparently, so far he's been able to, but it just takes once. All right. So tax shelters, page 112. And I told you I'm working, I've been working, and just to show you the tax shelters at the time, and we're not talking small firms, the big accounting firms got involved in tax shelters, and the fees that they were charging, to give you an idea, were just intoxicating. And many firms, law firms and accounting firms, turned a blind eye, and their opinion writing committees just really just thought that they could get away with it. Because tax shelters, by the way, just keep in mind, prior to the year 2010 at least, prior to the year 2010, there was kind of a loose standard. It was judicial. When people would say, what's your authority that this tax shelter doesn't work? A lot of it came from, look at this 1985 case. To treat a transaction as a sham, the court must find, one, the taxpayer was motivated by no business purposes other than obtaining the tax benefits and entering into the transaction. And, so it's conjunctive, it looks like it. The transaction had no economic substance because no reasonable possibility of profit exists. Well, the first leg, when you look, says was motivated by no business purpose. A lot of tax shelters were pitched to taxpayers by saying, hey, the odds are small, but when you enter into this tax shelter, you'll probably get losses, tax losses that will shelter taxable income. But there's a chance we're gonna get you involved in straddles. That was a common technique. And there's a chance that the straddles may pan out, maybe 1 in 100, but there's a chance that you're gonna make money on this. So in addition to securing the tax losses, there's a chance that you're gonna make money by investing in these tax shelters. And you wanna know the truth? Behind the scenes, these straddles often orchestrated, and this is public, this is not me disclosing anything that's not public. Deutsche Bank was responsible for like 90% of these tax shelters and these straddle arrangements. They had arranged it where essentially no one could win. But on paper it looked like you could, but they manipulated both sides of the straddle. So they made their fee, but the taxpayer could never really, could never make a profit. I thought someone was chiming into my Deutsche Bank story. So, in retrospect, just to prove me correct, to my knowledge, and I've looked at hundreds of these cases, no one ever did make a profit. Okay, so you might say, well, wouldn't Deutsche Bank allow at least one person? Because by allowing one person, you can always say, there was one person. Nope, because if Deutsche Bank did that, they would have cut back on their profits. So they didn't allow anyone to make profits. They made all these fees, these straddles. But the point I'm trying to make is the taxpayer was motivated. And we've always said, when it comes to taxpayers' motivations, it's very hard to ascertain what are taxpayers' motivations, right? Do we really know the mindset of taxpayers? And that extends to the tax shelter area. What was their mindset? And I would argue, and I'm gonna have to argue because I'm gonna be this witness in this upcoming case, that taxpayers often enter with a dual mindset, right? They want to potentially make profit, but they want to save taxes too. Which one is predominant? Is questionable. My point is, during the 1990s and the year 2000, tax shelters were in high gear. There was a lot of aggressive confidentiality agreements at the time. Congress had to enact, I think it's Code Section 6707, capital letter A, a reporting requirement that if you enter into a confidential agreement, you have to report that, both the person who's pitching the idea and the recipient of the idea. So Congress, but it took many years for Congress to do it. And Congress, like I said, in the year 2010, instituted Code Section 77010, which codified this, because there was a lot of questions about how this rule applied, this amorphous common law notion from Rice's Toyota, how this rule applied, was it conjunctive, disjunctive, all sorts of things. It was not clear, okay, truly not clear. And then at the bottom of our, bottom of page 112, there's Code Section 77010 that memorialized this and makes it much harder in the year 2019 to enter into tax shelter arrangements. right? So, keeping that in mind, and dealing with issues of client confidence, is let's talk about some of the problems that the authors present, because these come up in practice. Your firm represents 18 different clients who invested in a transaction sold by the same accounting firm. For each client, you must prove that the client had a profit motive for investing in the transaction with the IRS called a tax shelter. You recall under Code Section 6662D, there's a loose definition of what is a tax shelter. Essentially, a transaction entered into to secure tax benefits, but for no economic reason. Can you offer the same profit motive for each client, expectation of a specific return on a series of hedging transactions? So, can you represent multiple clients, guys, who all entered into, and many of them, they went by all sorts of different acronyms. Do you guys know any of the acronyms of these different tax shelters?
Blip.
Blip.
Wasn't that one?
Yeah, that was one. Not as, I didn't see as many of those.
Bond linked,
Boss, Son of Boss, Pop is the new one I'm dealing with, Cobra, all sorts of different acronyms for different of these aggressive tax shelters that they came up with to entice their clients. And part of the mentality back then was, hey, you're an idiot, you're a chump if you don't. Everyone else is. So when you went to the country club, this is what where is Mar-a-Lago? Did I say that right? Mar-a-Lago. You go to Mar-a-Lago, this is what everyone's talking about, right? So now can you represent the same people? I should have told Janet that this place is the temperature. I don't know, Viva, I'm looking hot and Ping, you're wearing a coat.
I'm not sure.
It's kind of warm in here. I don't know. I think Kevin's got the right idea. Just a t-shirt. All right. Can you do this? Is there a problem? So Brian, what do you say? Can you represent 18 different clients? Do you have any conflict of interest there?
Yeah, I think you could if you have waiver and disclosure, but you probably can't use the same profit motive for each client.
Why not?
Because they all have different situations, different motives.
On one hand, you might think, depending on their socioeconomic, where they are, they could have different possible profit motives or whatnot. On the other hand, I'm just sharing with you that many times these tax shelters were pitched with, like this Cobra transaction, the same profit motive, that you're going to enter into the straddle, and it may not pay off, but if the currency changes by a few pennies, it could pay off. So you should get consent by your clients that, hey, you have many people similarly situated, and unless there's extenuating circumstances, they may all have the same profit motive because they were all told the same thing. Now, should they have believed it? That's a different issue. So for your notes, and you're going to hear this a lot. You're going to hear it here. I hope you guys take it outside the classroom too. That, you know, just as I was a big subscriber to that Form 8275, that telling your clients about considering making disclosure, you're going to hear me a lot say the same thing again, about getting consent from your clients. I just worked on a unique consent where I represented the daughter in her estate planning, and her parents came to me a few weeks ago to do their estate planning. They're leaving it all. They have a son and a daughter, okay? Get the visual. I represented the daughter, and then her parents come. And to whom are they leaving their assets? All to the daughter. So what did I do?
Disclosed.
Who do I disclose to, Kevin?
The son.
I told them up front, I said, good productive meeting. I understand completely why you're leaving everything to your daughter. The son is married, doesn't have children, the daughter has children. The son is never gonna have children, so they're fearful that, just take a number, they're worth 10 million, that if they leave 5 million to the son and he leaves it all to his wife, their daughter-in-law is gonna end up with her side of the family, because us men 80% of the time predecease our wives, right? So they said, we wanna leave it all to the daughter because she has the grandchildren. So what did I do? I said, look, I can do this, but I'm not doing it unless you get a signed waiver from your son that I can do this, because I don't, you might say, well, they have good reason, you could do it, why not? I mean, but the son can always say, if I didn't get the informed consent from him, that, gee, you were biased in favor of your client, namely my sister, to instruct my parents to leave it all to her. You had an implicit bias, right?
Would that be the case if you did the parents' will first and never change anything for them, and then the daughter comes along after the fact?
That should be okay.
Yeah,
I mean, timing is important here. If I did the parents' will first, where they left everything to the daughter, and then she came in.
Yeah, because then there's no really conflict.
There's no conflict, right? That does get to be problematic if and when they want to perhaps change their documents.
Right, in which case you can say you need that disclosure.
Yeah. So it's just tricky. And when I talk to you in a few weeks about my own personal malpractice issue that I had, I've tried to be much more sensitive to these issues, but as sensitive as I am, you can, every other month I'd say, gee, what's going to happen with this one? Ping, I'm not here to scare you. Ping ended last class, said I'm never going to go into private practice, that she's staying up nights thinking about these things. But you know, you just try to be very sensitive. And I know some practitioners who say you haven't earned your stripes unless you get sued. Like, you know, it's just part of doing business.
I feel like it's unavoidable in today's day and age. Everybody sues everybody for everything, no matter how many times and how diligent you are. Maybe frivolous, but you're still going to get sued nonetheless.
You probably will, but you want to try to minimize that. And, I mean,
absolutely.
And it's easy to, like, this course is, I'm trying to give you some shields so that you minimize the times, right? So you don't look for trouble. 3-11.
So in 310 we cannot.
You can. I would get consent. 311, if the profit motive or business purpose is an essential element of proof to obtain a deduction from a tax shelter investment, there's representation of multiple clients who invested in essentially the same transaction dilute any single client's chances of obtaining a favorable settlement, or impose ethical constraints on the lawyer when additional clients are added to the representation. And you know, Brian, I come back to you because does this color your opinion in any form? Like, can you?
I'm not sure.
Anyone have a response to this? Dee, do you have a response to this?
I think this should be okay. Would it dilute any single client's chances? No, if it's the same transaction. It sounds like something similar to a class action or something.
I mean, in some forms, we're going to see, it's not clear from the problem who is, what is at stake here. If this is something where the IRS has successfully challenged the tax shelter investment, or if this is still at a stage in which they're considering entering into the transaction. So I'm not sure if the problem is crisply presented. So for your notes, I think that the fact that there's multiple people who are investing in the same transaction, well, I assume of obtaining a favorable settlement. Let's pause for a moment. That presumes the IRS has already said this tax shelter is flawed. So you're trying to obtain a favorable settlement, presumably with the IRS, right?
But why would it dilute any single client's chances? It would dilute everybody's, or no,
Well,
I mean,
the
nobody.
question is, when you negotiate with the IRS, do you think you have a stronger or weaker hand when you're negotiating with the IRS to settle an issue? If you have 1 client or 100 clients or 50 clients or 1,000 clients? If you're looking to settle.
Probably 1,000 clients.
Why do you think you have a better chance to settle?
Because it's less work for them if they're pulling to come to a settlement, and they can go focus on other matters that are gonna.
Well, the IRS may be advantageous, but for your individual client, who's better or worse served? I mean, if you have 1 client, you could be a little bit nimble, negotiate, and try to tailor specific settlement. When you deal with 1,000 clients, right, often, you know, you're narrowly constrained about what might be the permissible bounds of settlement. So, I think the problem is just, can you give, remember, whether you're a lawyer or accountant, you're supposed to give unwavering advocacy on behalf of your client, right? And you're not supposed to consider other, or have other considerations. And if you have client A, but only by making some sort of concession regarding client C, can you get a settlement, you may not be doing justice to client A, right? Because had you represented A alone, you might have been able to get a more favorable treatment. So just raised rhetorically, and again, it comes back to the old mantra, that if you're representing multiple clients, let them know, right, that this may bring constraints. They may say, fine, there's some economies of scale, maybe the fee, your fee will be less. But they should know in advance, because if they find out later, they think you're representing just them, right? And you're giving 200% to them, and then they find out you're also representing 20 other people, and they think that in some form or respect they didn't get what they deserve because you made too many concessions to strike, as you would say, John, a global deal with the IRS. You may have problems. So, again, sorry for the repetition, but let everyone know who you're representing and why. (3-12). With informed consent of the parties, your law firm has undertaken representation of investors in a tax shelter in proceedings before the tax court, which tax benefits of the shelter are being challenged. During the pendency of the proceeding, a separate class action is brought against the tax shelter promoters on behalf of a putative class consisting of investors in the shelter, including some of your firm's clients. Your firm does not anticipate participating. So remember, your firm is challenging the proposed assessment in tax court, saying, hey, this is a legitimate tax shelter, we shouldn't be hit with penalties. But at the same time, you're considering orchestrating a malpractice suit against those who are commencing, or who orchestrated the tax shelter, because you're afraid the statute of limitations might lapse. Your firm does not anticipate participating as counsel in the class action on behalf of the other side. Can your firm continue in tax court representation? Can the promoters pay? In other words, if you were going to say something?
No.
If you're suing the promoters, everyone understand that your clients entered into a tax shelter arrangement. The IRS is coming, right? Guns loaded, saying they owe big bucks, right? And your clients are unhappy that the IRS is attacking their tax shelter. They're also unhappy that they're involved in the tax shelter, so they want to sue the promoters, right? So they're engaging in battle on two different fronts, right? And the question is, can you represent both? What potential conflict do you see for representing both here?
Well, if you're representing them in front of the IRS, you're trying to present the benefits of, what the strengths of the tax shelter. And if you're representing the same people against the promoters, you have to present the weaknesses.
You're saying, let's take the latter first. When you're suing them for malpractice, you're saying this is a flawed tax shelter.
Yeah.
It's hard in the same breath as you're saying, promoters, you sold us a bad bill of goods, to turn around to the IRS and say, this is a legitimate tax shelter, we shouldn't bear any 66, 62 penalty, right? You see that the practitioner has to potentially occupy two different spaces, to B's point. So there's potential conflict that you as a practitioner might have. Now you could, and practitioners did this, say, look, we subscribe, I saw this, we subscribe that this tax shelter is legitimate. They would do that in front of, but we are bringing an action against the promoters to keep the statute of limitations open. What is the statute of limitations? We'll learn this in a few weeks for malpractice, accounting malpractice in New Jersey. Maybe you don't want to hear this, Peg, but how long is it?
5, 10, 7.
Tax shelter, promise no limit.
No. Remember, it's a tort action, but it's generally 6 years from the date of discovery. So, something that you did wrong a while ago, and it takes, say, the IRS, generally, how long does the IRS take to? IRS will generally, it'll be like in the middle of year 2.5, right? Because 3 years is the general statute of limitation. And then that may take some time to resolve itself, right? So you prepare a return in the year, for this year in 2020, and the IRS audits in the year 2023, right? And it gets resolved in 2025, right? Right, whatever the discrepancy with the IRS, you get hit with penalties, whatever. And then your client has 6 years from that date, say 2030, 2031, to bring a case against you for a tax return you prepared in 2020. And that can take several years to resolve. Because remember, a malpractice, is it criminal or civil? Civil, right? And unlike criminal you have a right to a speedy resolution. Civil you have no right. So those cases often take 4, 5, 6 years to resolve. So be a lengthy process again.
So it was 6 years the last day of what?
From the date of discovery. And when we have our accounting malpractice person come in, you can ask him more about that. And I'm going to leave you with a question. We'll get back to these questions. What is one of the hardest things you can decide when it comes to accounting malpractice? What is one of the hardest decisions you will have to make when it comes to accounting malpractice?
This is before being sued or after?
My question is in the process. The hardest thing, I think, one of the hardest things, you'll find, there's many things that are hard. One of the hardest things, though, is when do you put your malpractice carrier on notice? And why is that hard to decide?
Because the rates go up a lot.
Well, what if you don't get sued? And then unnecessarily they will increase your rates and.
On one hand, there's clients who are aggravated with you, right? And I don't mean this badly to anyone here in terms of your practice abilities, but, maybe every month or every other month or every few months you get a call from a kind of angry client about something. Do you put your malpractice carrier on notice?
Trying to resolve it.
But what concern do you have if you don't put your malpractice carrier on notice?
They won't cover you when it's really crappy.
Right. Your policy says that as soon as you think or know that you have potential litigation, that you have a responsibility to put them on notice. And they don't want self-help. They do not want you, they want to make clear that you should not be your own lawyer to try to resolve it informally with a client, because you can do some foolish things. So your policy, every policy ever written, says that you have an obligation to put them on notice at first sight of a problem. And what is the favorite word of your malpractice carrier, or words? John alluded to it. You're not covered, right? So you gotta be, there's a very hard point. You don't wanna tell them about every discrepancy you have with clients. On the other hand, you can't just sit on something and wait until you necessarily get served with papers, because your client may say, hey, there's email exchanges from 3, 4, 5, 6 months ago where you knew that this was brewing and you didn't put us on notice. We're not covering you. So you've got to be really careful and know where there's a role for email exchanges and when you got to pick up a phone. And
leave no breadcrumbs. That's a good rule.
you got to be careful when you even think you leave no breadcrumbs, because we know Michael Cohen taped Donald Trump. Do you think Donald Trump had any idea? And in this day and age, as V's taping this class, you just don't know who's taping what. So it is a very different environment than even phone calls these days can get you into hot water.
Communicate with your clients through only one of those really crappy encrypted messaging apps that leave no trace.
I can't tell you that. All right. So for your notes, for 3-12, you got to explain to your client that, again, it makes sense because the attorney may know the case so well. It's easy to argue in front of tax court. It's easy to put together a complaint against the promoters, but there may be a problem there. The fact that the promoters are paying, okay, your professional fees, I think, again, requires that you make disclosure. If you think that's going to jeopardize your representation, then that's a problem. But assuming, hey, they're just paying the fee because they don't want to make matters worse, I don't think that's an inherent conflict. But you should, when in doubt, disclose, right, guys? When in doubt, disclose. Problem 3-13. A accounting firm has developed and promoted a tax shelter which your firm's client invested. Can your firm represent the client at the same time it represents the accounting firm in malpractice cases that do not involve tax shelters? So you represent an accounting firm. I'm just using KPMG. Can your firm represent a client? Say, Trevor, if you can hear us, we're going to say the firm represented you in a malpractice case against the tax shelter. You want to be in a position where you're suing an accounting firm that you represent. I think you know the answer to this, right, guys? Evan, you were going to say?
No, I was stretching, sorry.
Yeah, even though, you know, in this case, you represent the accounting firm that have nothing to do with tax shelter cases. And I want to go there. The second question is obviously easier. Can your firm represent the client at the same time it represents the accounting firm in malpractice cases that do involve tax shelters? Well, certainly, that's an emphatic no, right? That you don't wanna do that, because one way or another, you're gonna undermine one of your two clients, right? But I do think when you have a client, it's hard to be in a position where you're suing your existing client, even if it's unrelated. So, on problem 3-13, neither of these look possible. Certainly the second one is impossible. The first one, I would say, stay far, far away from. 3-14, your law firm's banking department does loan documentation work for a bank that provided financing for a tax shelter transaction. A tax department client invested in one such tax shelter. Can the firm represent both the bank and the investor? And again, the authors are being, it seems to be a little bit repetitive here, but Mike, what do you say here? No, can't do this, right? Because, I mean, we don't know if the loan documentation, like Deutsche Bank was involved in a lot of these transactions I mentioned. If the loan documentation pertains to tax shelters, well, you can't, you don't want to do that. And even if it doesn't, then you should not be involved in any transaction that involves suing an existing client of yours. Just doesn't ever come out well. 3-15, your law firm represents a large insurance company, a general corporate and regulatory matters. Insurance company sold a transaction which the IRS alleges is substantially similar to a listed transaction, which the insurance company claims was substantially different from the listed transaction to an investor. And you represented the investor in connection with an IRS audit. Mike, does your answer change here, or can you do this? Now, who are you representing here?
Insurance company?
Well, you are representing the insurance company, but you're also representing the investor, correct? And who is the investor doing battle with? The IRS, not with the insurance company, at least not yet. Can you represent the investor? And you're saying no, why not?
The investor which is against.
Read the problem carefully. Where do you see a conflict? Do you see a conflict?
Isn't both have a different issues? Some, because they mentioned they have similar with the investor and IRS, but insurance has a.
I mean, during the exam, by the way, and with your clients, listen carefully, read carefully. I mean, so, Viva, do you see conflict here?
No.
Do you see conflict? Mike, do you see conflict?
Is it the actual transaction that was first, I guess, listed as what it was, and then changes once it's sold? Meaning that it wasn't accurate, the transaction.
Who wasn't accurate?
The transaction, there's a difference in what was originally, I guess, stated, and now once it's being audited. So somehow the transaction listed is not the same.
I mean, it's the same transaction, just so you know. I mean, go ahead, B.
The investor might blame the insurance company.
Well,
because
absolutely.
the
At some
IRS
point,
is-
it loses against the IRS.
Right.
They turn around. And,
Right, so then it's not a good idea to
but
make this up.
pause for a moment.
As of the moment, there shouldn't be any problem because it's between the IRS and the investor.
Right. For the moment, remember, you are representing a client, namely the investor, who's doing battle with the IRS. The insurance company hopes you prevail, right? And if you do, done. And if you don't, right, suppose you're unsuccessful against the IRS and there's a large penalty. Well, then the investor may turn around and sue the insurance company, and at that juncture, to Kevin's point, from a timing perspective, you wouldn't want to bring that suit, right, Kevin?
Yeah, exactly. That's where you say, no, I don't want to get involved in this anymore.
Well, you shouldn't, and
Yeah.
you don't want to. Be careful because clients get irked when you say you don't want to.
I
Say-
shouldn't.
Just blame it on an external thing, authority. The ethical
Can't say I just got
guidelines
this thing.
require that I cannot be involved. Okay, because otherwise it's misconstrued that the client's like, why, you know, we've been together all these, why aren't you giving me, you know, everything you've got, John?
Can't they like turn around and say you were representing the insurance company the whole time and like weren't looking out for my best interest?
Well, keep in mind, I mean, here, at least for the moment, the insurance company and investor have a coterminous interest, which is to, so, if anything, the client, the attorney might have a better incentive to try to do everything here, so, it should work.
Okay.
I mean, you could always, in virtually anything you do, and be careful, guys, for exam purposes and with clients, you could always find a potential conflict lurking on the horizon, okay? So there is a happy medium, because if you look for every conflict in the world, you're out of business, okay? Truth be told, you're out of business. If you blind yourself to every conflict, you're out of business because you're gonna be sued so often. So you do have to strike that happy balance, and that's my point for exam purposes and outside the classroom, that don't bury your head in the sand when it comes to potential conflict. On the other hand, do not, in this particular scenario, you should be okay. Okay, estate planning is an area rife, depending on the pronunciation, where conflicts of interest may come up, both for accountants and attorneys. I've worked with lots of accountants, and often we join forces with accountants to mutually represent people with trying to achieve their estate planning objectives. And obviously, this is an area of potential landmines because there are potential conflicts of interest. With spouses, when is the most common conflict of interest, guys? What is the most common? Amari, what's the most common scenario where there's a conflict of interest?
Not sure.
You have a scenario, Andrew, you have a scenario where you say, this must come up a fair amount of time?
I'm certainly in separations and where assets are gonna ultimately end up, that becomes a conflict.
Oh, no, I'm talking about, I'll use the adjective happily married couple. When do you have the greatest
When
likelihood?
there's an ex.
Children from prior terms.
But there's no X, oh, hold on. What scenario is the most common that you, I mean, happens all the time.
Was children fighting against each other and.
Well, hold on, I'm just talking husband and wife.
Oh.
Children fighting, it could happen.
The husband leaves the money to the children and not to the wife?
Well,
I mean, just representing both spouses.
Assuming the wife
both
is the
spouses, now,
stepmother?
look, what does that mean?
If the wife is a stepmother and the husband left it to the kids but not to his wife, she would be upset.
Is it the age of the ages, meaning, you know, if you're doing an estate planning for each, it should
determine either maybe the health, who's gonna live longer, who's not, and then when you have that wealth, whoever goes first, where to go, how to distribute it, something like that.
When I say this, I hope this resonates with both. Anytime I'm across the table from a couple that has a second or third or fourth or fifth marriage, there's a problem or a conflict of interest, right? Because they will either, in the scenario I depict, where one or both have, it's a second marriage, and they have children from a prior marriage, okay? Then each one has an inherent agenda, right? So husband and wife, John and Mike, for the moment, you're married, but it's a second marriage for you both. John has 2 children, A and B, from his first marriage. Mike, you have C and D from your first marriage. It's a game of chicken if John leaves it all to Mike, and Mike says, and I've had this happen. I can't make this up. I wish I had a videotape of this. I'm sitting across the table and I say, John, if you leave it all to Mike, there's a good chance that Mike, upon her demise, no offense to your children A and B, she's not gonna leave it to A and B, she's gonna leave it to her children C and D, right? Everyone have that vision? Does that seem rude on my part? Does that seem, I'm telling you.
It's realistic.
Well,
I feel like you're almost obligated to disclose that.
Yes.
Well, the wife, and I said that, and you think I was the devil. She said, she looked at me, you don't know me, that's so unfair on you, of course I would leave it to all
Well, exactly,
four.
you don't know her, that's why you gotta say that.
It's true, and I kept saying, I say this to everyone. I didn't say it because I looked across the table and I thought you were a bad person. I say it to all second marriage clients. That was it. I never saw them before. Again, I spoke to the accountant and she said she was just too upset with she took it personally. But that to me is a telltale sign to John, or John I met. Be careful, because she ain't never leaving it to your 2 children. If you know, the old Shakespeare, she doth protest too much. But you can see, and I've had a lot of second marriage couples where neither has children. So if John and Mike don't have children, but John wants his assets ultimately to get back to his side of the family, and Mike wants it to get back to her side of the family. So whether they have children or not doesn't dictate the outcome. The harder situation, if John has children, Mike has children, and now they have child E together, okay? So that creates its own issues, because now they have the common bond of the one child. I have, this is my 2 cents. You may not share this, and some couples do, and my job is to give people options, and everyone see the inherent conflict, right, in that kind of situation, okay?
Maybe have a form that's called like second marriage disclosure form. Make it
Well,
look
I
like
do.
it's not you just saying that.
Every
Just,
time
I'm required to show
I
you
have a
this.
dual representation letter anytime I have a second marriage, and I insist they sign it, okay?
We could like spin it, make it look like, even if you're a sole practitioner, my firm requires me to go through this with you, regardless of how uncomfortable.
Well, it doesn't matter. I mean, it wouldn't have mattered, I'm
Yeah,
sure. And some clients aren't worth having, that is never gonna work. Because what are your options when you have a second marriage couple, guys? And what can you do? What would you, suppose John this were, you were married, what would you try to do then in that scenario? So John, what would you guys do? How would you plan your estate? And you're each worth $2 million, just to make up a number, so what might you do?
$2 million each?
Yeah.
One, determine where his portion is.
Yeah, how are you gonna leave your estate?
Can I say my $2 million goes to my kids, or?
You can say it, whatever you want. What are you gonna say? So you're gonna leave all $2 million to your kids?
Sure.
Now, Mike, are you happy with that?
Yeah.
No.
My mistake.
I mean, is it normally
I would do the
spouse
same
and
thing.
spouse?
I mean, you might feel, gee, That's not too nice of you. We've been married 10 years, 20 years, 30, and it's great that John's looking out for his children.
If he earned the money, that's his money.
Boy, I haven't met too many of you out there. The notion is, hey, I need this financial protection. His children are able-bodied. They'll do it on their own.
But you already have $2 million, so why would you need?
Well, people have different ideas. Andrew, you were going to say?
I mean, you can use trusts, Q-tip provisions.
All right, so
giving families access
the
to
point
income.
I and Andrew's affirming, there's two, in my mind, there's two very different routes you could go here. One is, John dies, he takes his $2 million, he leaves it in a life estate for you, Mike, and you live for another 5, 10, 15, 20 years, and upon your demise, it goes back, it swings back to John's 2 children, and your money goes to your children. So establishing a so-called life estate in that $2 million is a very common direction that people go in. Now, what do you think of that, Andrew, since Andrew just came back from Herculing dealing with estate planning? So you obviously do a fair amount of work in this area.
Yeah.
So having said that, Andrew, is that good or bad, that kind of planning? Do you like it? Do you gravitate towards it? How does that work?
I mean, I find with my clients, at least, as long as the assets ultimately get where you want them to your beneficiaries, but during the life of, say, the other spouse's kids, if they have access to the income and even some principal of money that you maybe leave in trust for them, I find that's pretty amicable.
Here's the issue.
But not always.
Not always. 2 issues, my opinion. First of all, John and Mike, can they decide on a trustee, right? Because John dies, every day Mike's gonna have to look at a trustee and say, can I get X dollars? Depending on the terms of the trust, she's gonna be here on one side of the table, the trustee's gonna be on the other, right? So that can be a very, very difficult, contentious dynamic, right? And the second contention is that John's children, A and B, every day Mike is above ground instead of below ground. They may not be, she's the evil stepmother, right? They may not be happy campers, right? And, they may, it's hard to walk around, Mike might not care, she may be thick-skinned, but, her kids, her stepchildren are not her biggest fans being alive, right? And some people don't care, some people really disdain the fact that, whatever. So one direction is creating this life estate, but it creates its own complexity. What I try to say is, hey John, this is rough justice. There's no right or wrong. And by the way, what's good for the goose is good for the gander, so I'm gonna say the same thing to Mike, that John leave Mike, and he's worth $2 million, maybe he leaves Mike or gets an insurance policy for $500,000 or $1 million. He dies, Mike gets some X dollars. Again, what the source is, could be his money, it could be an insurance policy. And the balance he gives to his kids, and they walk away. Is it perfect? It's not perfect because there's no perfection in this game. But this way, they don't have this, if Mike lives another 5, 10, 20, 30 years, they don't have this potential, encounter. I mean, a lot depends on the circumstances. Maybe it might help raise John's children because each one got divorced at a very young stage and there's a whole different relationship. But if it's a much later stage of marriage, the situation I'm portraying may make sense. Andrew, you're gonna chime in?
I see that too. I mean, it's a good way to equalize the estate. But
The word equalization is probably a misnomer because you're not equalizing,
or
rough justice.
make more parties happy.
They tried to.
But it's cost of insurance, it depends on your age, insurable.
A whole bunch of different factors there. Just things to think about. So the point I was getting to is conflicts of interest. You don't have to look too hard. Like Viva, we were saying before, sometimes you look too hard. Here, you don't have to look too hard. There can be conflicts of interest. With respect to families, between and among different generation levels. There can be other conflicts because siblings are notorious about going after each other, and you've got to be really careful about that. And then what about the businesses that these people own? So the global point here when it comes to estate planning and why is it under client conflicts, and again, don't just think this is an issue lawyers deal with, you'll never have it cross your practice. Accountants routinely that I've worked with are working hand in hand with me about trying to get things done. And if I'm being sued, by the way, I'm gonna hold your hand, we're gonna be sued together. Because my brethren, attorneys, plaintiffs' attorneys, when they sue, they go shotgun. And they sue anyone who touched the file, all right? So, hey, by the way, if I didn't give you any closure, I wanna give you a happy end. Because I told you I was a little bit peeved that this attorney who was coming sent me an email. I think I told you that someone asked for some documents, and then I said, here's the documents, and said, can I use your office? And I said, yes, you can use my office. Then said, oh, would you mind procedurally reviewing these documents? And I said, I didn't want to touch it because I knew once you touch it, it's like kryptonite. It can be pulled under. Anyway, he respected that, and here's the happy end. He came to the office, he was very gracious, and he said, I know you don't drink, but I brought you golf balls. He didn't know I don't golf either, but that's a different issue. And he gave me a Starbucks card, which is always golden, and I go to Starbucks and I'm thinking, I got my Java chip, whatever, and I just said to the barista, just how much is on the card? Did I tell you this last week?
Yeah.
I did.
You did.
Okay.
$100.
$100, thank you. So, I just still sticks with me how gracious some people are. I mean, I wasn't looking for it, but I was very impressed. All right, page 115. We have a New Jersey Supreme Court case. By the way, this one case I'm involved right now in two different cases. One case I may be flying out to California to testify. But for your entertainment on Tuesday, if anyone wants to go to the Newark courthouse, the Federal District Courthouse in Newark, Tuesday morning I'm told that I'm going to be the first witness called on this tax issue. So wish me luck on Wednesday. Promise to have some stories. And no, I don't think, I cannot have you tape. I don't think they allow that. Or else I would definitely share
Well,
it
the
with the
court
class.
will tape it themselves, right?
I don't know how that works.
Okay.
I've been in a lot of, every case I've had to testify as a fact witness, never as and I've been an expert witness in a lot of cases, but they all settle. This is the first time any settling. So, it'll be interesting. If there is a tape, I will bring it and we can watch it on the board. I don't think there will be. Or I'll send it to you. I want to force you to watch it anyway. Page 115, Pascal case, 1988. To me, this is somewhat an entertaining case, but sometimes I shouldn't be entertained at other people's expenses. So I apologize. There's a great word. I hope most of you are most of you familiar with the word Schadenfreude?
Shadow what?
I guess not. You never heard the word Schadenfreude?
That sounds German.
It is German. You might, but it has no relationship to the word Freud. Some of you may have in your yesterday.
Oh, wife.
Schadenfreude was presented. There's a song I should send to you from Avenue Q. Anyone ever see the show Avenue Q? You did. There's a song called Schadenfreude. And this is going to be a word, you guys, for the rest of your life. You're going to say, when I learn it, you're never going to remember the source. Tax class, why would it? Schadenfreude means joy in another person's misery, okay? And it's a terrible thing to do, but we periodically, like when Rush Limbaugh was arrested carrying OxyContin, it's like, wow, he's got his due, right? But I felt badly because it's Schadenfreude, like joy in another's misfortune, right?
It is what it is.
Or comfort in other people's sorrows.
Karma.
I'm sure there's equivalent in every language.
Is there? I thought that was just uniquely, like, it's not like a good trait,
Misery
right?
loves company.
What?
Misery loves company.
Misery
You're miserable, you like seeing them miserable.
No,
But it's not that you're miserable
No.
necessarily.
No, taking comfort in other people's sorrow, that's the equivalent.
Right. Look at it. Anyone can Google it for the spelling, but Schadenfreude, I'll have to send it to you guys. And if you get a chance, I'll have to Google the song Schadenfreude because it is a very good take.
SCHADENFREUD.
Oh, it's spelled slowly, V, for the.
Yes, SCHADEN, Schadenfreude, like Freud, Sigmund Freud, with an E at the end.
You want me
And
to
what's
play
the
the song?
definition?
I can play the song.
Pleasure derived by someone from another person's misfortune.
Can we just get the first few lyrics? Andrew, can you play it loud? Lee.
Let me see.
Let's see if Andrew can.
There's no such thing as a perfect writer. Listen.
Try it. Let's hear it. Guys, keep quiet for 1 minute and then we'll tell them.
Right now you are down and out and feeling really crappy. And when I see how sad you are, it sort of makes me happy. Sorry, Nikki, human nature, nothing I can do. It's Schadenfreude, making me feel bad that I'm not you. That's not very nice, Gary. I didn't say it was nice, but everybody does it. You ever clap when a waitress falls and drops a tray of glasses? And ain't it fun to watch figure skaters falling on their asses? Don't you feel all warm and cozy watching people out in the rain? That's Schadenfreude.
Anyway, we got the gist.
That sounds too happy to represent that word.
Well, that song is supposed to be you're so joyous that the other one's
Oh, okay,
falling apart.
okay.
Schadenfreude. You'll see it now. It's one of those words that. Anyway, so this case, you're watching this train wreck, and anyone have a chance to read it and tell us about what happened here, the dynamics? Peter, you're gonna say?
And so the father, who Pascal, who basically founded the company, later on opened up another parent company, so it was two companies.
Okay, and picture, if you will, taxpayer, or father here has two sons, right?
In Hoboken.
Hoboken, he has two sons, David and John Jr.
And he gets divorced, and each kid sided with one parent. But Pascal's, I guess, stayed working with his son, David. And then
So
when-
picture, if you will, John Jr. sides with mom, David sides with dad, and dad is not the, how do we say, the most upstanding citizen.
Yeah.
He's backdating stock ownership certificates to
Give his wife less.
give his wife less, but he's got David on his side, right? And aside from David, he apparently has the same advisors, right? He has the same accountant, this guy Schwartz, and he has an attorney, Berkowitz, who's going to help him do things. And then you're going to see something, again, I see routinely, and this is your antenna should go up, but I try to be more sensitive to this. At the bottom of page 116 on to 117, early in his representation of both matters, Berkowitz communicated exclusively with Pascal. Pascal, however, directed Berkowitz to deal, quote unquote, directly with David or Ben, but primarily David. According to Berkowitz, Pascal instructed him to develop an estate plan that left everything to David by incurring as little tax liability as possible. David confirmed Berkowitz's testimony by acknowledging he served as agent for Pascal dealing with Berkowitz. So this is very common, particularly in a day and age where people live to be in their 80s, 90s, even centenarians, is that the right word? Centenarians? Is that they delegate things to their children. And now you've got to deal with their kids as proxies for the parents, but what do the parents really want? Okay, Peter, so what happens here?
Down the road, I guess, when it came in the end, the issue was original shares that were legally transferred really belonged to him. So that caused the problem because when they were trying, when David basically was trying to take the
All right, so let's pause for a moment. Dad wants to make an arrangement with David to potentially give him the stock, but does Pascal, or the main plaintiff here, does he really own the stock? Because remember, it's not entirely clear. But if you look on page 118, the first full paragraph, the main dispute in this case is whether Pascal understood those documents affected an outright transfer of the quality stock and real estate to David. So in other words, there's paperwork created in which David is going to be the big winner here, right? He's going to get all the stock, securities. Now, who represents Pascal? Who represents David? The same attorney, the same accountant, right? Everyone agree? And listen, I am sure, I'm not sure of anything, but I'm pretty sure that there was a lot of hobnobbing going on where Pascal and David, and the attorney and accountant, you got the visual, I have the visual. They did a lot of hanging out together and everything was very, very friendly. Everyone agree? Is there any doubt in your mind? I mean, at least there's no doubt in my mind that they were having donuts or bagels or whatever, food, cuisine, if they were drinkers, wine, whatever. These people were on the same page with one another. That's my take. And Pascal, once the deal settles, he's not happy because he thought, right, Peter, he was going to have control. He argues that maybe he didn't care, but subsequently he did. Why did he subsequently care? Did he and his son?
John start talking again.
Yeah, the family's dynamic switched where all of a sudden.
He started helping John Jr.
Well, David started helping his brother out at the father's expense. And things took such an ugly turn. When I say ugly, I mean, when you read this, and I have, well, the second full paragraph from the bottom of page 118, it says, on the same day, David executed a will prepared by Berkowitz in which David bequeathed all of his quality stock to a testamentary stock trust of which Pascal was the trustee. The beneficiaries were Pascal and David's wife, and all the income was payable to Pascal during his lifetime. One more year later, in 1980, however, David executes another will which eliminated the trust and provided the quality stock. The land would pass to his wife if she survived, and if she predeceased him, to his mother-in-law. Oh my God. I mean, you know things are really, really bad if your son is on his will, instead of leaving it to you, is leaving it to his mother-in-law, right? That is a slap in Dad's face. Maybe that's true.
Well, the mother-in-law was probably a good grandparent.
I can't.
But I don't believe that was the purpose here. I just think it was to stick it to the father at the moment.
Yeah, I think that was, I think so too. So things were really, really bad, but at the end of the day, why is this case here, Peter?
Because the same attorney was representing that, and in essence, both clients were not being told what the other was doing, and David, the father, claimed that he never really was explaining the document that he signed. The other side saying yes, you were, and it's like he said, she said, back and forth. And there was no true disclosure for waivers given to each one of them. Nobody really consulted, apparently, I think, of what the other was doing properly.
Yeah, I mean, I lived this. When I say I lived this, I had in my practice where the father, I told you a bit about this, but where the father came in, told me his two sons, any dealings his two sons were to handle it. He was just going to come in and sign the paperwork. And the sons orchestrated this deal, and the daughter, their sister, his daughter, was out of the picture. And then some years later, an attorney, just like this guy Berkowitz, had orchestrated a deal between the father and the son, and everything was great until it wasn't, and the father came in to me with his daughter and saying his sons ripped him off, and he had McCarter English, which is New Jersey's largest firm, bringing a lawsuit against his sons because he feels that he got shortchanged, and the attorney was sued for malpractice. And that was one case I dodged that bullet. They tried to bring me in, I told you as an expert that I orchestrated the deal, and fortunately the judge did not permit that to happen.
It's just that in the beginning when it says that, you know, the father basically had David be his representative, take care of all matters, so it became an issue with David, and Berkowitz was always involved together more than the father. And then once things went sour, then the father was like, wait a minute, what really went on? Being that the father allowed, or apparent to this, David, the father allowed the son to handle all matters for him, did the attorney still have, you know, obligation to go back to the father and say, hey, listen, this is what we discussed, this is what we went over, even though the father allowed the son to just basically do almost everything?
You want the reality? Here's my answer, the academic answer, and then the practical answer. The academic answer is you should provide as much detailed information as possible to your client. You want the real answer? Because I know dealing with my client, and this is not just a one-shot deal, I see this routinely, is these people are, I'll call them busy, or they don't want to be dealing with it. So you could say, I want to meet with you because I had these long conversations with your son, and I want to explain what happened. They're like, I trust him, I don't have the time for this, I don't want to, so, but then it's up to you to document that you try to do this. And you'll hear from the malpractice attorney, what's one easy way to handle these kind of phone calls that you might have? One, to cover yourself, protect.
Record them.
Say again?
Record them. Record?
Record. Well, you gotta be careful about recording your own client. But my go-to method, again, I'm gonna repeat this several times, you'll hear me. In your billable records, when you bill a client, time entry should say, spoke to client, offered to explain in detail that you know, whatever dealings with son about A, B, C, and D, client preferred that we skip the conversation, you know, something more eloquent than I'm saying. But if you can get that in the billable record, and not in a way that you're looking to be contentious with your client, but just memorializes what actually happened, then if and when your client sues you, you can say, you know, your attorney will say, look, and we'll have your client understand, Mr. So-and-so, do you see this date? Do you see this time entry? Did you pay this bill? Does it say that you refused to talk about this particular issue? How do you think that plays with the jury? So billable records are so key. Do not just put point 3, spoke with client. You'll hear from the malpractice attorney. That is, who knows what you said. But if you add a little description, and not a description to say to the client, hey, I'm protecting myself, but just being honest, that is worth its weight in gold. So do yourself a favor, guys, with your billable entries. Do it in a way that you create silos so that these kind of things are less apt to haunt you. I'm not saying they won't, because the client who's angry may sue you, to John's point, but if you have these things on the record, it's going to make it so much harder. And that's where 9/10 of these cases settle. And part of the favorable settlement is if you have good billable records, you know, you can settle for a lot less than might otherwise be the case. So we have this case in which, you know, just really brings to light the conflict. And page 119, the last full paragraph says, as previously stated, a lawyer cannot serve 2 masters in the same subject if their interests or may actually or potentially conflict. And if I didn't mention to you, and because we had spoken about it last class, keep in mind in Appendix H of your textbook, that our authors offer you, if you turn to Appendix H for 1 second. A whole, a few pages of how accountants have this same issue of a conflict of interest. And in malpractice cases, often these ethical standards are used by plaintiffs' attorneys to say that if you violate these rules, you're unethical. And like I said, sometimes juries have a hard time understanding the underlying transaction, but they do understand generally ethical rules. And if you have a situation where there's a real conflict of interest, they may just think you're a bad person and gee, bad people should be punished, and we'll give plaintiff an award. So just, you really don't want to try to run afoul, but if you look like you're a person which you get your dual representation letters, you get consents because you're an upstanding citizen and you try to act ethically, even if you don't mind me saying, you've committed some flaw of some sort, maybe the jury will say, gee, this is a good person. They shouldn't have to bear, some sort of onus because they don't understand the real transaction. So this is in your control. These are actions that you're here on a Saturday morning, you're here on Wednesday nights. Try to absorb this stuff, guys, because a lifetime of practice, if you subscribe to some of these simple rules, you hopefully will be protected. So bearing that in mind, if you're not protected, at least you'll be fed. So I understand, I know Dee brought food, I brought some food. Dee, but who brought the donuts? Oh, Ming, thank you. So guys, why don't we take our 15-minute break now, and there's bagels and cream cheese, there's bananas, there's donuts, there's yogurt, there's
almonds and mini croissants.
Wow. So no one's gonna go